Subcommittee on New Offenses and Change Penalties will come to order. The clerk will call the roll.
Chair Louderback,
Here.
Representative Moody, Representative Money,
Here.
Representative Bowers, Representative Little.
Let's see here. Yeah. A quorum is present. What is this first? The chair lays out House Bill 2461 as pending business only for the purpose of clarifying a witness registration. The chair calls Adam Colby. Mr. Colby, you are currently registered in support of HB 2461. However, you would like to change your position to neutral, is that correct?
Yes, as my position with the, working for the Financial Crimes Intelligence Center, it should be neutral.
Okay. Does the clerk have your permission to change your position on House
Yes.
Bill 2461 from for to on the bill?
Yes, they do, sir.
Thank you. If there is no objection, HB 2461 will be left pending. Chair hears none. I'll keep it open. Oh, so we got David Emmerich. Chair calls David Emmerich. Mr. Emmerich, we're asking for permission for the clerk to delete your registration for House Bill 2461.
That's correct.
That's right. Okay. All right. Need to do anything else on that? We're good. If there's no objection, House Bill 2460 will be left pending. The chair hears none, and HB 2461 is left pending. Okay, where are we at? All right, so what bill is this? The chair lays out House Bill 3507 and recognizes Representative Wharton to explain the bill.
Thank you. Mr. Chairman, members, I will be as lengthy as possible because we haven't been doing anything all day today. Thank you for the opportunity to lay out House Bill 3507. This legislation addresses a very real and frustrating issue faced by retailers, law enforcement, and communities across Texas, habitual shoplifters who continue to reoffend. Under current law, someone who steals less than $2,500 has 2 or more prior theft convictions can be charged with a state jail felony. But whether they have 2 convictions or 20, the penalty remains the same. That lack of distinction leaves prosecutors and courts without the tools they need to hold serial offenders accountable. House Bill 3507 proposes a tiered penalty system to target those who've made a career out of retail theft. First, it keeps the existing punishment in place for individuals with 2 to 4 prior theft convictions. Second, it increases the penalty to a 3rd-degree felony for individuals with 5 to 9 prior theft convictions. And for the most chronic offenders, those with 10 or more prior convictions, it increases the penalty to a 2nd-degree felony. This bill is not aimed at first-time offenders or those who made one bad choice. It is focused on repeat offenders who repeatedly exploit the system, impact small businesses, and drive up costs for honest consumers. By enacting House Bill 3507, we give prosecutors another tool to deter serial theft and support the businesses and law enforcement officers who deal with this issue every day. We have a witness here today from Walker County. He actually stayed through the entire day, just want that noted in the record, that has firsthand experience with this issue. I respectfully ask for the committee's support on this bill, and I'm happy to answer any questions, and I reserve my right to close.
Thank you, Representative Warden. Members, are there any questions for Representative Warden? Seeing none, if there are no questions, the chair will call the first witness. The chair calls Will Durham. Hello. Thank you for being here today, District Attorney Durham. If you would, we show you registered as Will Durham, testifying on behalf of the Walker County Criminal District Attorney's Office and yourself. Is that correct?
That is correct.
Wonderful.
I'm in support of this bill. Thank you to Representative Wharton for sponsoring this important bill that addresses just one of the problems with habitual thieves and repeat offenders. The issue we're seeing is that it's a defendant that has 2 or more, or like Trey said, 20 or more, is going to have the same punishment. And so this bill addresses that problem by broadening the theft enhancement provisions for those habitual thieves who continue stealing over and over again for amounts below $2,500. These particular class of people never incur consequences beyond a state jail felony, and they're never in jail very long. My office and others around me and the counties nearby have many habitual shoplifters and thieves who fit into this category, and unfortunately our local stores and businesses know them too well. Just this last grand jury last month, we indicted a defendant for theft with 2 or more prior convictions as a state jail felony. But this particular defendant had 12 prior convictions, and yet their potential incarceration time is the same as it had been for their 4th, 5th, 6th, or 12th, or 20th, or 50th. This new bill would just allow judges, juries, and prosecutors that option to pursue higher penalties for habitual shoplifters and thieves. And like Representative Wharton said, it's not for the person that made that one bad choice. It is for the habitual thief, and it is a bill that would be a big help. And I have also the support from Montgomery County, Grimes County, Washington County, and Montgomery and Madison County. Those DAs are behind it as well. And so I appreciate y'all's time and consideration of this.
Thank you, District Attorney Durham. Just to be clear for the record, you registered for the bill, correct?
I'm registering for the bill.
All right. Members, do we have any questions for District Attorney Durham? Seeing none, thank you so much for
Thank
your
you.
attendance here, and I'm sorry for the extreme delay.
okay.
We appreciate your service.
I was invested and I was going to stay.
Thank you for that
Thank you.
sacrifice, District Attorney Durham. Is there anyone else who wishes to testify on, for, or against House Bill 3507? If not, the chair recognizes Representative Wharton to close on the bill.
Thank you very much, and I urge your favorable consideration, and I close.
If there is no, thank you, Representative Wharton. If there's no objection, the bill will be left pending.
Thank you very much.
Is there objection? Chair hears none. House Bill 3507 is left pending. Chair Lay, who else we got? Fairley, do you see her? Let's go to Dyson. One second. Just pull the number. 1 second. Chair lays out House Bill 1871 and recognizes Representative Paul Dyson to explain the bill.
Thank you, Mr. Chairman, members of the committee. Peace officers across the state of Texas have been under assault by individuals wanting to do harm simply because of the uniform they wear and the job they perform in protecting our communities. HB 1871 focuses on this threat and will provide a stronger deterrent to those willing to take the lives of our heroes in blue. Currently, both attempted capital murder of a peace officer and aggravated assault against a peace officer are considered first-degree felonies. HB 1871 seeks to address the issue by increasing the punishment related to the attempted capital murder of a peace officer to reflect the heinousness of the charge. There are 3 key provisions of HB 1871 that I'd like to point out to the committee. First is the increase in punishment range, changing it from 5 to 99 years to a minimum now of 25 years and no more than 99 years. This increase is not merely punitive, it serves as a necessary deterrent against violent acts towards our law enforcement. Also, HB 1871 denies parole to those serving a sentence for attempted capital murder of a peace officer. And lastly, the bill denies mandatory supervision of an inmate serving a sentence for or has been previously convicted of attempted capital murder of a peace officer. In short, I've worked very closely with our Brazos County District Attorney Jarvis Parsons, who's here to testify today, along with 2 officers from Brazos County who've been here also all day. While I'm happy to answer any questions that you may have, I'd like to defer to him to speak directly to the necessity of this legislation and perhaps answer any of the questions that you may have. With that, I would like to reserve my right to close.
Thank you, Representative Dyson. Members, are there any questions for Representative Dyson? If there are no questions, the chair will call the first witness. Chair calls District Attorney Jarvis Parsons. Thank you, sir. Thank you for being here today. We show you registered as Jarvis Parsons, Brazos County, on behalf of the Brazos County District Attorney's Office and on behalf of yourself, and you'll be testifying for the bill. Is that correct?
That is correct.
Wonderful.
Yep. I started off my remarks by saying good morning before, but it's obviously good afternoon.
Sorry about that.
That's okay. Good afternoon, fellow committee members. My name is Jarvis Parson, and as a 23-year prosecutor who has seen almost every type of crime here in Texas, I'm here today in support of HB 1871, which increases the penalties for attempted capital murder of a peace officer in Texas. Every day, law enforcement faces deadly threats from individuals who wish to end their life for no other reasons than the badge they wear. And every day, those officers still put on that uniform and go out to protect the men, women, and children in their jurisdictions. However, in the status quo, if a person has specific intent to murder a law enforcement officer in the course of their duties and does everything in their power to end that life and does not get to their desired goal, that person is still eligible for probation in the state of Texas. And the punishment for attempted capital murder is the same as recklessly causing bodily injury to a public servant and just exhibiting a deadly weapon. HB 1871 solves that problem and gives officers the protection they deserve and when individuals do everything in their power to end their lives and leave their children without a mother or a father. It does two things. One, increases the punishment from a minimum of probation to a minimum of 25 years up to life in prison. And two, denies parole to those individuals so there's actually truth in sentencing. So individuals who are sent to prison for trying to murder police officers stay there for their entire sentence given to them by a judge or jury. Today you'll hear from individuals, retired College Station police officer and current Deputy Constable Calder Lively and Lieutenant Ed Ramirez with the Brazos County Sheriff's Office about instances in their own departments that are indicative of the danger law enforcement faces around the state from people who want to do them harm. Thank you for your time and your support.
Thank you so much, and thank you, Mr. Parsons, for being so patient today and for the sacrifice of being here. Members, are there any questions for this witness?
I think you know a friend of mine. Oh, I'm sorry, Mr. Speaker. I have a question.
It's Chairman Little.
Mr. Governor.
The chair recognizes Representative Money.
Mr. Parsons, it's been a long day.
It has.
I got a call from someone I think that's a mutual friend of yours and mine this past week. I think this is I already had read this bill. It's a great bill, and I couldn't believe that that it hadn't been addressed before. So thank Mr. Dyson and for yourself for working on this and for sticking around here all day. Thank you.
Thank you.
Seeing no other questions, thank you so much, District Attorney Parsons.
Okay.
The chair calls as its next witness Lieutenant Edward Ramirez, Brazos County Sheriff's Office. Welcome, Lieutenant Ramirez. I show you testifying on behalf of the Brazos County Sheriff's Office and on behalf of yourself, and you're testifying for the bill. Is that correct?
Correct.
Thank you. Please proceed.
Good evening, Chairman Little, committee. My name is Lieutenant Ed Ramirez. I worked for the Brazos County Sheriff's Office for 30 years. Today, I'm going to talk about one of my deputies. On December 30th, 2022, Sergeant Brittany Ray was ambushed while performing her duties as a patrol sergeant as she tried to apprehend a dangerous individual. This individual had shot a Bryan police officer the night before. On the day upon seeing her vehicle after the ambush, it was clear to me that the suspect had no other motive than to kill her. I observed 10 rounds traveling up the front of the vehicle and into her windshield. 2 of the rounds had struck her headrest. Brittany was injured but survived. She took shrapnel in the eye and shoulder, and at the time believed she had been shot in the head, yet she still remained calm. After shooting at Brittany, the suspect continued to flee but was surrounded by other responding officers. For several hours, the suspect continued to shoot at officers while evading on foot through the woods until he was finally stopped by SWAT members. Recovering from an incident like this took time and trust in our legal system. It was difficult for me as a peace officer and for Sergeant Ray as well to understand why an individual who had tried to kill her could potentially get probation or parole. House Bill 1871 closes that loophole and ensures that individuals who intend to murder a police officer don't get that chance at parole. I ask that the punishment for the attempted capital murder of a peace officer fit the crime. Merely because one survived should not be the reason for a lesser punishment when it is clear the intent was to end the life. Help us correct this injustice and not give individuals such as this a second opportunity to kill a police officer. I ask for your favorable consideration for House Bill 1871.
Thank you, Lieutenant Ramirez. Members, do you have any questions for this witness? Lieutenant Ramirez, I remember reading about this case, and it's a very tragic situation. thankful that Sergeant Ray was able to live. It's horrifying that that could be the potential range of punishment outcomes. And I know you do a very difficult and dangerous job. I just want to thank you on behalf of the people of the state of Texas.
Appreciate that. Thank you, sir.
Hearing no other questions. Chair's calls Calder Lively, Chief Deputy Constable, Brazos County District Attorney's Office. Chief Deputy Lively, I show you as testifying on behalf of the Brazos County District Attorney's Office and yourself. Is that correct?
Yes, sir.
And you're testifying for the bill.
Yes, sir.
Please proceed.
Chairman, members, my name is Calder Lively. I retired from the College Station Police Department after 23 years of service, and I'm currently the Chief Deputy Constable of the Brazos County Precinct 3 Constable's Office. I've been a peace officer for over 30 years. I rise today in strong support of House Bill 1871, which increases the penalty for the attempted capital murder of a peace officer to a first-degree felony with a sentence of 25 to 99 years or life without eligibility for parole. A case I was involved in personally was on October 16, 2020. A subject decided he wanted to kill people in our community. He drove to a local park full of families and college students. He, for no reason at all other than that he wanted to kill somebody, he shot a college student in the chest multiple times. I found him a few minutes later. He shot at me, hitting my patrol car 4 times, hit the dormitory building behind me and other cars that were behind me. I was able to take him into custody, and he is serving time. There's another constable in Brazos County that was shot and killed, Brian Bachman. Also, former co-workers when I was at the College Station, Officer Brad Smith of 38 years. One of my other deputies have been shot at. This is a very serious problem. Every day, Texas peace officers put their lives on the line to protect our communities. When someone attempts to take the life of an officer, it is not just an attack on a person. It's an attack on the rule of law, the safety of every citizen, and the reputation of our community. There were several parents of A&M students that were very shocked and horrified at what was going on. So it's not just local, it affected the reputation of our community. House Bill 1871 sends a clear and necessary message. Texas stands with its law enforcement. If you attempt to murder a peace officer, you will face the full weight of justice. Please back the brave men and women who protect us, and I urge your support for House Bill 1871.
Thank you, sir. Members, any questions? Thank you, sir.
Thank you.
Chair calls David Simmons. David Simmons.
He left. I believe he left.
Is there anyone else who wishes to testify on, for, or against House Bill 1871? If not, the chair recognizes Representative Dice to close on the bill.
Thank you, Mr. Chairman. I think you heard it. When we talk about the specific intent that's required about this crime, we just need the punishment to fit that crime. With that, no more questions, then I close.
Thank you, Representative Dyson. If there is no objection, the bill will be left pending. The chair hears none, and HB 1871 is left pending. So where's that paperwork at? Okay. One of them had the paperwork on it. Here it is right here. Yeah. The chair lays out House Bill 4911 and recognizes Representative Fairley to explain the bill.
Thank you, Chairman members. Introducing 4911 as a necessary and timely update to Texas child protection laws in response to emerging technologies. This last session, Senator Huffman, she passed legislation making it illegal to possess or distribute
Maybe just a minute. The chair offers a committee substitute on this, is that correct?
There is no committee sub on this.
Okay. Thank you, go ahead.
Okay. So this last session, Senator Huffman, she passed legislation making it illegal to possess or distribute AI-generated child sexual abuse material. Since then, we've seen that technology has advanced rapidly, and the law needs further updates to close these dangerous loopholes. So the purpose of HB 4911, it updates existing statutes to ensure protection for children in the age of AI and deepfakes. It expands definitions and clarifies the scope of illegal content. The provisions of this bill, it adds two critical definitions. It is a criminal offense to have a fake image of a real child, and it also is a criminal offense to have an entirely computer-generated image that appears to be a real child. So these cover real kids, fake images of kids. It clarifies criminal offense, so such that it is a crime to knowingly possess or view these types of images when the person knows or believes that the child is under 18. To close on this, the reason this bill is so important is, one, technology should never outpace our commitment to protecting kids in Texas. Just last year, there was a Texas mother. She found an AI-generated explicit image of her daughter circulating online. The image looked real, but was completely fake. This girl, she's 14 years old. Her name is Elliston. And the worst part about this situation was that law enforcement struggled to act because no law had clearly been broken under existing statute. The mother said it didn't matter that it wasn't her body. The trauma is real, and now my child is the one who has to carry it. This bill ensures that situations like this, like 14-year-old Elliston, do not happen again. And it makes it clear that fake or real child exploitation is unacceptable in Texas. HB 49, it ensures that Texas leads the way in protecting our children in the digital age. I thank you for your time and reserve the right to close.
Thank you. Any questions for Representative Fairley? Go ahead.
Thank you, Representative Fairley, for your bill. This is a very extensive rewrite of 4326. We've had it in the Criminal Jurisprudence Committee. We've heard a number of bills that have touched on 4326. I want to bring something to your attention that I
Yes,
think
sir.
is significant. So on page 10 of your bill, Section 1, you have rewritten a series of affirmative defenses into that bill. It's sections H-1 and H-2 of the bill.
Okay.
H-1 being, it's an affirmative defense to prosecution under this section that the conduct was for a bona fide educational, medical, psychological, psychiatric, judicial, law enforcement, or legislative purpose. I would submit to you, Representative Fairley, that there is no bona fide educational, medical, psychological, et cetera, purpose or use for child pornography. I can understand if law enforcement needs to review it for purposes of determining its existence for prosecuting an offense, but this is a major passion of certainly one component of our party's legislative priorities to remove these affirmative defenses, and I hope you would consider removing sections H, or at least significantly modifying section H-1 as it relates to the affirmative defense.
Thank you, Representative. So I will, and I would love your feedback on this, because we added and had affirmative defense in there, to your point that you just said, that if it is a person's job to review these, we don't want them to be legally obligated to be under criminal offense. So if you have any suggestion to still protect those people who have that job to review these, I would love to hear that, but we can touch base offline.
Yeah, I think if I were writing it, and I wrote a bill actually on the existing 43, 24, 25, and 26, the affirmative defenses, I would limit it to a judicial or law enforcement purpose.
Okay, we will make that note.
So
That's
don't
helpful.
be surprised if there's a friendly amendment sought.
Well, we will take a look at that, because you're right. We want to make sure that it is as secure as possible, that we don't have loopholes. So thank you so much.
Thank you. The chair recognizes Representative Bowers. Is it as back?
Okay. Thank you, sir.
The chair will call the first witness. The chair calls Sheriff Hawthorne, Brian Hawthorne. Let's see. Brian Hawthorne. No, not here. The chair calls J.W. Wilkerson, John Wilkerson. John Wilkerson. The chair calls Stephen Driver. Thank you, sir. We show you as Stephen Driver,
That is correct, Judge.
and you represent who?
I'm representing the Harris County District Attorney's Office and myself
Thank you. And you're
And-
testifying on for or against House Bill 4911?
for the bill.
For the bill, thank you. Go ahead.
Good afternoon, Chairman Lauterbach and committee members. My name is Stephen Driver. I am the Division Chief over the Human Trafficking and Child Exploitation Division of the Harris County District Attorney's Office. I've been an Assistant District Attorney for 17 years, and I've handled many child exploitation-related offenses, including child pornography and other related offenses. And I thank Representative Fairley for this bill because we have actually seen it in practice already that we need something like this. The legislature has recently, or in recent sessions, made some strides towards helping law enforcement, but unfortunately, technology has outpaced legislations, not surprisingly, because it moves really, really fast. What we have now is the ability to charge people if a recognizable child's image is used to create child pornography, like you face switch it, in other words. What we're starting to see in our cases are actual images that are entirely AI generated, and AI is one of those things that every day improves in quality. So what we saw months ago were images that looked more like anime images, where the facial features were exaggerated, but they looked like real people. Now they look real. They look like real images of kids. And the concern here is that we have individuals using these images to either exploit children, to groom children, or to engage in fantasies related to child sexual abuse. And that's something that we see in these kinds of cases all the time, is the use of fantasy to slowly and gradually build up to hands-on abuse. And so the fact of the matter is that we have a real danger related to this kind of imagery, even if it's not an actual child, that we have an offender that's using it to build up to actual touch offenses. So the problem is that if we do nothing, we're putting children at risk, and that's simply not acceptable. And I'm happy to answer any questions.
Members, are there any questions for the witness? Representative Little.
Thank you, Chairman. Just 1 second, let me pull this up here. So, Mr. Driver, you may have heard me ask some questions to Representative Fairley about the
Sure.
affirmative defense piece. Have you ever been involved in a case in which the affirmative defenses were used or applicable? Can you think back to one?
I haven't seen them used personally, mainly because when it comes to the law enforcement exceptions, we recognize that in our charging decisions. We don't move forward if we believe there's a bona fide law enforcement purpose for having the images.
Of course, and that's to be expected. That, I mean, there are bona fide judicial or law enforcement purposes to have to review the material for purposes of prosecuting
And discovery.
crimes, certainly, and discovery. So the question I have for you is, have you ever encountered in your practice, this is, let me start over. This is actually a really important question and broader reaching than maybe perhaps this bill. Have you, in your practice, prosecuting crimes involving harmful content, child sex abuse material, child pornography, whatever we want to call it, have you ever encountered a situation in which there was a bona fide educational use of the material?
Primarily in the arena of training law enforcement. So, and I would actually go a little farther. There is a program that the Department of Homeland Security started in 2013. I was one of the first trainers, where disabled veterans were used in something called the Hero Corps to help actually detect and stop child pornography offenses. So they, in other words, became law enforcement or a branch of law enforcement. And it was a bona fide educational purpose where we were able to use those materials in a very limited circumstance to train.
Don't you agree that would fall within the law enforcement privilege?
I would hope so, but I like the idea that education within law enforcement is also covered, at least training.
Okay. Thank you.
Any other questions for the witness? Thanks, sir.
Thank you.
The chair calls Caden Lopez. Caden Lopez. Is there anyone else who wishes to testify on, for, or against House Bill 4911? If not, the chair recognizes Representative Fairley to close on the bill.
Thank you, members. Representative Little, I want to go ahead and let you know that we are going to be working out and reaching out to your office to make an amendment to that affirmative defense, working with Huffman's office. So we'll reach out to you to get that working on. Thank you for your offer. And with that, I close.
Thank you, Representative Fairley. If there's no objection, the bill will be left pending. The chair hears none, and House Bill 4911 is left pending. On House Bill 795 by Representative Johnson, the following motion in writing by Representative Bowers. I move that the subcommittee chair inform the committee chair that the subcommittee has completed its deliberations and recommends that House Bill 795 be scheduled for consideration by the full committee. The question occurs on the adoption of the motion. Clerk will call the roll.
Chair Lauterbach,
Aye.
Representative Moody, Representative Bowers,
Aye.
Representative Little,
Aye.
Representative Money.
2 absent, 3, 4.
There being 3 ayes, 2 nays, the mo-
0 nays.
do what?
0 nays, 2 absent.
Yeah. 3 ayes, 2 absent. The motion prevails. Members, that concludes today's agenda. Any further business for the committee to address? If not, the committee chair moves to adjourn. Is there objection? Hearing none. The committee stands adjourned and is subject to the call of the chair. Thank you.